5 seconds to go. Start. The appellants filed an application for grant of compensation on the premise that they suffered damages owing to the acts of rashness and negligence in driving on the part of the respondent number 2, the owner of the vehicle, as also the driver thereof, were thus principally liable to pay compensation to the dependents of the deceased. A contract of insurance is a contract of indemnity. In a case of accident, the primary liability under law for payment of compensation is that of the driver. The owner of the vehicle also becomes vicariously liable, therefore. In a case involving a third party to the contract of insurance in terms of section 147 of the Motor Vehicles Act 1988, providing for a compulsory insurance, the insurer becomes statutorily liable to indemnify the owner. Indisputably, the insurance company would be liable to indemnify the insured in respect of loss suffered by a third party or in respect of damages of property. In a case, therefore, where the liability is fastened upon the insurer would be bound to indemnify the insured unless the exceptions contained in section 149 of the Act are attracted. It has not been disputed before us that in certain situations, while opining that the insurance company would not be liable to reimburse the insured, a direction upon the insurance company to pay the amount of compensation to a third party and recover the same from the owner of the vehicle is permissible. Such a direction has been issued by the High Court. The said directions are not under challenge. Keeping in view the aforementioned principle in mind, the question which arises for our consideration is as to whether it was permissible for the High Court to interfere with the quantum of compensation as awarded by the learned tribunal, although no appeal was preferred either by the owner or the driver of the vehicle, nor any appeal was preferred by the insurance company. Indisputably, in relation to a third party, the grounds upon which the insurer can deny its liability are contained in subsection 2 of section 149 of the Act. Ordinarily and subject to just exceptions, the insurance company would have no right to question the quantum of compensation in absence of any leave having been granted in its favor in terms of section 170 of the Act. The High Court, with respect, failed to consider this aspect of the matter. Appellants preferred appeals before it on limited grounds. Their contentions could have been rejected or accepted. The High Court, however, could not have considered the contention raised on behalf of the respondent number 3, which was not available to them in law. it was legally impermissible for the respondent number 3 to question a finding of fact arrived at by the tribunal, taking umbrage under Order 41, Rule 33 of the Code of Civil Procedure or otherwise. It is well settled that what cannot be permitted to be done directly cannot be permitted to be done indirectly. Stop.